Hello, everyone. Welcome. Welcome to Legal Writing 101. We're just going to give folks some time to join us. But in the meantime, let us know your name and where you're joining us from. I'm Carlos. I'm coming from Oakland, and I'm happy to be partnering, my organization, ChangeLawyers, to be partnering with the John Paul Stevens Foundation for this legal skills series.
Hi, everyone. My name is Anjali, and I'm the program director of the John Paul Stevens Foundation. And I'm so thrilled to be here to launch off our series with ChangeLawyers to learn more about legal writing and support all of you all. So happy to be here. And I am tuning in from San Diego, California.
And I'm seeing folks coming in from all over the country, so that's really cool. We have fellows and scholars, both of our organizations, all over the place, and it's really great to see the impact that you folks are having. This has been a very highly requested topic. It's probably the one that we could ask for the most, and it seems to be incredibly beneficial to folks. Not a topic that you learn in law school, from what I understand. And we're going to be actually having a part 2 next week, a week from today. You can register for that in the description. The links are there if you haven't done so already. And we're going to be doing Oral Advocacy 101, and then a part 3 at the end of March. That's going to be on issue spotting. So I'm going to give folks maybe like 30 more seconds to join, and then I will bring up our teacher for the day, our presenter. And like just a reminder again, in the comments, let us know who you are, your name and where you're joining from. And a reminder that throughout the session, if you have any questions, type them in, and Tiffany, our instructor, will be able to answer them. We're going to have some time at the end for general questions, but if you have any specific questions about the slides that or the topics that Tiffany's talking about, send them in, and Tiffany will see them and we'll be able to answer them. Okay, so let me bring on Tiffany onto the stage. Hey, Tiffany, welcome.
Hi, thank you so much for having me. It's a pleasure to be here.
We're super excited to have you. This is not the first time that ChangeLawyers has worked with Tiffany. And we're working with Tiffany again because the last time we got rave reviews from our fellows about the topic that you covered and how much more at ease they felt after your instruction, and more importantly, your experience as someone who's working in this and has like living real life experience on the topic. So with that, I'm gonna let you take it away, and we'll see you for Q&A at the end.
Great, sounds good. Thank you. All right. So it's so nice to be here with all of you. I can't see you, but I am excited to see all the people introducing themselves in the comment section. It's amazing that you all are joining us from all over the country, and thank you for being here. And I'm so happy to be speaking with you today about Legal Writing 101. And basically what I hope to cover today is just some really basic tips and tricks to make your legal writing as effective as possible. As Carlos mentioned, I think sometimes legal writing doesn't get emphasized as much in law school because there's so many other substantive courses that we need to cover. But really, legal writing is sort of the foundational tool and skill that we need to have as lawyers, because legal writing is how we communicate with each other. So with that in mind, let's dive in. Okay, so first of all, why are we here? Why even bother trying to improve our writing skills? So as I mentioned, the ability to write well is really critical to any lawyer's work, and frankly, any chosen field, because writing is sort of the prevalent way that we communicate with one another, especially in this age of technology. But going back to the legal profession in particular, most lawyers will spend about 50% of their time writing. And if you're a newer lawyer, you're probably going to spend even more time writing, maybe up to 75% of your working day will be spent writing. And that includes writing emails, letters, memos, briefs. There's a variety of different types of documents that we need to write. But regardless, it takes up a significant amount of our time. And at the end of the day, language is a lawyer's primary tool. So just like any other skill, it's something that we need to practice so that we can continue to communicate effectively and hopefully communicate more effectively as time goes on. So, this course is designed to help refresh us on how to write like a lawyer, but what does that actually mean? Well, to me, and I think the trend in the law is sort of following this as well, writing like a lawyer means writing clearly and concisely and dealing with a problem by applying appropriate rules. What writing like a lawyer doesn't mean, even though I think it used to mean this, is obscuring meaning with wordy and jargon-laden prose. I certainly remember as a first-year law student reading opinions from early turn of the century courts that were really difficult to understand. The language, it was long, unclear opinions, really convoluted statutes. And I think the trend in the law has really been to move away from that over the past century or so. And so really, we want to try to focus our writing on being as clear and concise as possible these days. So here's just a quick overview of what I hope to cover today in our hour together. We'll briefly review what legal analysis is, and this will be a more abstract conversation. So then the next thing we'll do is we'll use some illustrations to help kind of provide some context for what legal analysis is. Then we'll discuss how to analogize and distinguish cases, and then we'll compare the different legal writing styles that exist. And then lastly, I'll conclude by giving some quick refreshers on how to write in plain English, which is really just sort of like a grammar refresher. And then if there are any questions, feel free to either save them for the end, or if it's specific to a topic that I'm covering, you're welcome to put to type those into the comment section. And as Carlos mentioned, they'll be highlighted for me and I can address them in live in the moment. Okay, so let's dive in first to the sort of more abstract review of what is legal analysis. So again, even though legal writing isn't highly emphasized in law school, hopefully you all received maybe one course in it. And chances are in that course, your instructor taught you something close to what I refer to as either the IRAC or the CRAC formula. Now, IRAC in this case stands for issue, rule, analysis, and conclusion. And then CRAC is very similar, but it stands for conclusion, rule, analysis, conclusion. But either way, no matter which formula you're applying, in essence, what you're trying to do is lay out the law and then apply it to the facts of your case. That is what legal analysis is. So turning first to the I in IRAC, the issue statement is going to be the thing that starts every discussion or argument section in the document that you're writing, whether it's a a predictive memo or a persuasive brief. The issue statement is going to be sort of the first thing that your reader sees, and it provides sort of the context for everything they're about to read. So it can either be the heading of a section in your discussion or your argument, or it can be, if there's only one sort of issue that you're addressing, it can just be the topic sentence. But either way, it's going to kick off your legal analysis. And then if you're using the CRAC formula, instead of the IRAC formula, then the way you phrase it will be not as an issue statement, but as a conclusion statement of what, everything that your reader is about to read. It's going to kind of summarize what the conclusion will be right up front. So after the issue statement or the conclusion statement, we turn to the rule section. So the rule section presents an overview of the relevant law for each issue and explains how the rules have been applied in other cases. So the temptation in the rule section is often to just kind of list every relevant case you could find and maybe summarize it. But you really want to make sure you're picking and choosing your strongest authorities and keeping the section as concise as possible, because you don't want it to just come off as like a laundry list or an inventory of cases. So there's definitely some kind of thoughtfulness that has to go into how you present the rules section, and we'll kind of go over some ideas for this in the illustrations discussion, which will come next. But generally speaking, this part of your legal analysis will lay out the general rules of law, and then if your issue has several sub issues, then you'll save the more specific discussion of those, the more precise rules for those sub issue discussions. So after you've laid out the rules, this is going to be the most important part of your legal analysis, is the actual analysis part of the discussion or the argument. So in this section, you're going to discuss how the rules that you've just summarized apply to the facts of your case. And the way you do that is by comparing and contrasting your facts with the facts of the other relevant cases that you've just discussed. And importantly, in this section, you're going to want to make the connections between the facts and the rules, even if the connection seems really obvious. And I say that because we'll talk about this later as well, but you never want your reader having to infer anything. You basically want to take them by the hand and walk them through your entire analysis from beginning to end, leaving them with no doubts, no questions, no need to really think for themselves. They just kind of follow your line of logic until they get to your conclusion, which is very legally supported. And hopefully by the time they get there, they agree with you. But either way, you don't want them having to struggle to figure out what you're trying to say. You just want to say it directly and make all the connections for them. So, and like I said, if you're in a situation where your issue has a few different sub issues, in the analysis portion, you're going to want to break those sub issues apart from one another and then discuss them separately. And so as you do so, you're going to want each of those sub discussions to follow either the IRAC or the CRAC formula, depending on which one you're using. And then lastly, the C in IRAC and CRAC stands for conclusion. So this is the part of your discussion where you will, in 1 or 2 sentences, summarize the analysis. And here again, you want to be direct and not leave anything to your reader's imagination. So just state it clearly, even if it feels a little repetitive. Maybe you can kind of rephrase the issue or conclusion statement you had at the beginning to avoid that feeling of repetition. But at the end of the day, the repetition is okay because the purpose of a memo or a brief is to have a legally supportable conclusion. So saying it more than once isn't a bad thing. Okay, so that's, again, very abstract overview of what legal analysis is supposed to be, but it's really hard to kind of conceptualize unless you see some examples. So let's dive into those examples. I think that will be the most helpful thing. Okay, so I'm going to put a fact pattern up on the slide. So imagine you're dealing with a case where Henry homeowner fails to mow his lawn and the weeds spread to the lawn of his neighbor, Gary Gardner, and destroy it. Gary sues for the cost of replacing his lawn with grass that resists this type of weed. He also requests an injunction forcing Henry to mow his lawn at least once a month. Okay, so that's going to be the fact pattern that we're working with. So let's begin with an example of what I consider to be sort of, bad legal analysis. So a bad legal analysis might look something like this. Gary is absolutely justified in suing Henry. Henry's failure to mow his lawn is nasty and is the cause of the destruction of Gary's lawn. Henry owes Gary for the replacement of a lawn. Gary should also get the injunction because good neighbors are supposed to mow their lawns regularly. Now, if we weren't in sort of this really large format where there are so many of you in attendance, I would ask, for members of the audience to kind of call out why do they think this is a bad analysis. But we're not quite in that setting, so I'll just sort of, cut to the chase and explain why I think it's not a strong analysis. And really, for me, this comes off as very opinionated, one-sided, and worst of all, it's very conclusory. Notice there's no reference to a single case or a single rule of law. So it really just feels like someone's opinion. It doesn't feel like there's legal support to it whatsoever. So if we compare something like that to something like this, we can really see what makes something a good legal analysis. So in the good legal analysis, actually, you know what, before, I'm not going to read it all the way through. We're just going to break it down. So let's start with the opening sentence. Gary Gardner has no legal right to require his neighbor Henry homeowner to mow his lawn or pay damages for weeds on Gary's property. Okay, we're in legal analysis, which means we're either going to follow the IRAC or the CRAC formula. Here, this first sentence is a conclusion statement. So we're following the CRAC formula in this example. If you were following the IRAC formula, you could say something instead like, the issue is whether Henry homeowner is likely to be held liable for his weeds damaging Gary Gardner's lawn. So again, you're kind of conveying the same information, but you're phrasing it as an issue statement rather than a conclusion. But regardless, that the first sentence we see here is stated as a brief summary of what the writer wants the reader to ultimately conclude when they get to the end of the analysis. Next, we get to the rules section of the analysis. So here it says, generally, a person is liable to another for damages only if he has a fundamental duty to take reasonable steps to prevent foreseeable harm and fails to do so. Under Giles versus Walker, and then there's a citation, a person is not responsible for damages resulting from the natural growth of the soil on his property. So in this rule section, we have two sentences. One is sort of a more general statement of the law, and then we have a specific case that illustrates that general rule. Okay, so now that we've done the conclusion statement and the rules, we now turn to the A in the CRAC formula, which is the analysis or application. And by the way, I've bolded the word here because here is a fantastic transition word that writers can use to signal to their readers, hey, what I'm about to say is going to be related to the facts of my case, not some other case, but the case in front of the court today. So here, the weeds are a natural condition of Henry's land, and Giles makes clear that Henry is not responsible for damages alleged to result from this natural growth. Gary may argue that the standard practice in this urban neighborhood is reasonable lawn maintenance, and Henry has therefore deviated from the standard of what is acceptable as natural growth. However, a reasonable jury would be unlikely to find that natural growth is determined by community standards. So again, what you see here is the writer has used the specific rules of law that they identified in the previous paragraph, and they've applied them to the facts of this particular case. And again, they use the word here as a transition to signal to the reader, this is what I'm about to do. I'm about to talk about the facts of my case. And then finally, we arrive to the to a kind of secondary statement of the conclusion. Based upon Giles, Henry has no fundamental duty to prevent harm to his neighbor's lawn and is not responsible for damages from natural conditions. Therefore, Henry is not likely to be held liable to his neighbor for damages resulting from the growth of weeds on his property. So again, it's sort of a slightly longer summary of the conclusion that was stated in that initial sentence. Okay, so that's one example. I'm going to turn to another one. Unfortunately, I don't have a fact pattern for this one, but the facts will become clear as we sort of talk through the illustration of the good legal analysis. Okay, so again, this is a lengthy one. I'm not going to sit here and just read the whole thing once through. We'll just kind of break it down sentence by sentence and discuss it that way. So let's start with the first sentence. The issue is whether our client Dave may be liable for battery for blowing smoke in Peter's face during a heated confrontation. So again, here we have a variation on the CRAC formula, which is the IRAC formula, because the first sentence is worded as an issue statement. If you were employing the CRAC formula, I've put some examples on the slide of what you could say instead for your first sentence. You could say something like, Peter is likely to succeed in his claim of battery against Dave. Or you could say something like, a court is likely to hold that Dave is liable for battery when he blew smoke in Peter's face during a confrontation. So those would both be conclusion statements if you were following the CRAC formula. Okay, turning next to the R in the IRAC formula, we have some rules. So first we're going to start with a general statement of the relevant rule. And then what we'll see is that we have two mini briefs that follow this general statement that illustrate the rule, or at least illustrate sort of the boundaries of the rule. So a defendant may be liable for battery where, by blowing smoke, the defendant intended to cause offensive or harmful contact, and such contact resulted. Okay, so here's the first mini brief that I referenced. For example, in Leichman versus WLW Jacor Communications, Inc., the defendant deliberately blew cigar smoke into the plaintiff's face while the plaintiff was participating in a radio interview on the dangers of secondhand tobacco smoke. And then you have a citation. First, the court observed that smoke was a particulate material capable of legally significant contact. Second, given the circumstances, the court held that the defendant had intentionally caused an unwanted contact. Thus, the plaintiff had pleaded a cognizable claim for battery. So notice that in this mini brief, you have the facts, the court's analysis, and the conclusion all kind of tied up in this neat little package for the reader. And the reason you do that is you're trying to give the reader every tool that they need in order to understand how the general rule of law that you're discussing applies to the facts of your case. So that's mini brief number one. Oh, sorry. Let's break it down a little bit more precisely. So first, as I mentioned, transition words can be really helpful in legal writing. So we talked about how the word here signals that you're about to discuss the facts of your own case. In this case, when you're mini briefing something, if you've just made a general rule statement, the next thing you could say would be, for example, which signals to your reader that what they're about to read is an illustration of the legal principle they've just read in the previous sentence. Next, we have a very brief summary of the relevant facts from the Leichman case. Then the mini brief discusses the appellate court's observations and holding. And then lastly, the mini brief ends with a description of the court's conclusion in that case. So that's sort of, you know, when you've selected the most important cases to discuss in your rules section, that's sort of the ideal way to discuss the case. That little mini brief package is going to be the most helpful to your reader to help them understand how the rules of law apply to your case later on. Okay, so we've talked about the first mini brief. Now let's look at the next mini brief that the writer employs. Okay, so again, this example, we'll break it down again, but essentially what you see is here, because it begins with the transition sentence, on the other hand, you know right away that the writer, what the case they're about to discuss is going to have reached an opposite conclusion from the case they just discussed. So again, transition phrases are so helpful in any time you're engaging in legal writing. Really think about, how can I signal to my reader what's coming next, and how does it, you know, either follow from or is different from what they've just read. So in this mini brief, we have, on the other hand, in McCracken versus Sloan, the defendant, who knew that cigar smoke was offensive to the plaintiff, smoked in the plaintiff's presence. Nevertheless, the court observed that smelling exhaled smoke was, quote, generally permitted contact and is not typically a basis for battery unless the plaintiff pleads actual physical harm from the contact. Without evidence of such harm, the court held that the plaintiff had not pleaded a sufficient case for battery. So just like the first mini brief, this one includes a little fact summary, a description of the court's reasoning, and then finally the court's conclusion, all kind of wrapped up in a neat little bundle for the reader. So now that we've laid out both the general rule and two mini briefs that illustrate that rule, we turn to the A part of the IRAC formula, which is the application or the analysis. And this is where you want to describe how these specific rules of law that you've just discussed apply to the facts of your case. And the way you do that is you compare and contrast the facts of your case to the facts of the other cases that you've just mini briefed. So again, notice that the writer employs a very helpful transition phrase in this case, and then goes on to say, Dave, in response to verbal provocation, leaned toward Peter and blew a plume of smoke directly into Peter's face. These circumstances are more analogous to Leichman, where the contact was meant as a physical provocation during a confrontation. Okay, and then here, what the writer does next is they actually highlight a potential counterargument that Dave could make for why a court should not find him liable for blowing the smoke in Peter's face. In particular, the writer says, Dave may try to argue that his exhaled smoke was merely an environmental circumstance and that Peter cannot show any particular consequential harm similar to McCracken. So notice again, you're as the writer, you want to acknowledge counterpoints to the position you think the court is most likely to adopt. But here you'll see that again, the writer ultimately concludes that Dave's argument will likely fail because the facts of their case are more similar or analogous to the facts of Leichman. So in particular, the writer writes, however, given the strength of the analogy to Leichman, a court is more likely to reach the same conclusion as that case and hold Dave liable for battery. Okay. So now that we've reviewed legal analysis and talked about a few examples of good versus bad legal analysis, let's talk more generally about how to use cases in your legal analysis. Okay, so we're dealing, again, here's a new set of facts to be thinking about. Sorry, I could kind of changing them up on you. So here, imagine that you are either representing one of the people involved in the following dispute. Ned next door has sued Hal homeowner and claims that the branches of Hal's tree are damaging Ned's gutters. There's only one relevant case, Smith versus Jones. In that case, a homeowner allowed the roots of his tree to clog his neighbor's drainage pipes. The court held the homeowner liable for the damage to the neighbor's property. So based on that very brief description, it's pretty clear that if you are Ned, or if you're representing Ned, you want the court to reach the same result that they reached in Smith. On the other hand, if you are Hal, or you're representing Hal, you are hoping for some sort of different outcome. So how do you advocate for that? Well, if you represent Ned, one thing you can do is argue that the facts of your case are similar to the facts of Smith versus Jones. So Ned would argue that the result should be the same and the defendant should be liable because the cases are about trees that damage neighbors' property. And that's essentially what Smith versus Jones was about in a broad sense. But on the other hand, if you're representing Hal, you want to argue that the facts are distinguishable. So Hal's attorney would argue that Smith is not useful authority because it deals with roots and not branches. It also deals with drainage pipes and not gutters. So that's one way to analogize or distinguish a case, is using the facts to do so. You can also frame it in terms of what was the legal issue presented in the case that you're talking about versus your own case. So if you're Ned's attorney, you would want to characterize the legal issue as the same or substantially similar in both cases. So Ned would argue that Smith dealt with the legal issue of damage to a neighbor's property by natural growth on adjacent property. Whereas if you're representing Hal, you would want to argue that the legal issues are different. So Hal would argue that Smith dealt only with the issue of a neighbor's liability with respect to drain pipes, not gutters. So again, just another way to analogize or distinguish Smith versus Jones would be to focus on the like I said, the facts or the legal issue. Okay. Another way to use cases is to focus on what was the holding in each case. So if you're Ned and Smith versus Jones is favorable to you, you're going to want to depict the holding as broadly as possible so that it clearly applies to your case as well. So Ned would argue that the court in Smith held that a property owner is liable for harm to a neighbor's property caused by a tree on the defendant's property. But if you're Hal, you're going to want to depict the holding of Smith versus Jones narrowly so that you can argue that the case doesn't apply to your case. So Hal would argue that the court in Smith narrowly held that a property owner is liable for harm done by his tree roots to a neighbor's drain pipes, which is irrelevant to harm above the ground. And then lastly, a final way you can analogize or distinguish a case in your legal argument is by focusing on what were the policy factors that drove the court's decision. So in Ned's case, he wants the same result as Smith versus Jones. So he would argue that similar public policy reasons warrant the same result. So specifically, he could say something like, according to Smith, public policy favors the requirement that property owners prevent trees or other growth on their land from damaging the property of adjacent neighbors. Whereas Hal is going to argue that sound policy supports a different result. So he would argue that under Smith, public policy requires that homeowner liability be limited to severe cases of interference with drain pipes on adjacent property, but liability should not extend to ordinary occurrences such as overhanging branches. So really, when you find a case that's relevant to your discussion or your argument, there are lots of different ways that you can use it to either help your client or distinguish your client's situation from the case if the outcome is bad for you. So again, and just to briefly recap, it was facts, issue, holding, and public policy factors. So we've kind of been so I know I talked about both IRAC formulas and CRAC formulas. And you may be sitting there wondering, how am I supposed to know when I'm supposed to use which type of formula? So, first of all, in theory, especially if you're a younger attorney, hopefully you have a partner or someone who was more experienced kind of guiding those decisions. But just as a general rule of thumb, here's some helpful things to look for in deciding whether to employ either the IRAC formula or the CRAC formula. So if you find yourself working on something like a predictive memo, or if you're taking an exam, then the chances are you're going to want to employ, to be fair, you could do either the IRAC or the CRAC formula, but that would be a situation where the IRAC formula would be very acceptable. And generally speaking, your tone in those types of documents is going to be more neutral, more objective. Any conclusions that you reach are going to be discussed more in terms of likelihoods and recommendations rather than absolutes. And you would also, remember in one of the examples, we called out a potential counter argument. These types of documents is where that situation would be highly appropriate, calling out a counter argument and then discussing it objectively. And so again, when you're doing that, you really can use either the IRAC or the CRAC formula. But if you are writing something like a brief or a motion or a letter to opposing counsel, your tone is going to be very different, and what you're trying to accomplish is going to be very different. So for those types of documents, you're really going to want to employ the CRAC formula only. And there, your tone is going to be more full of advocacy and almost like a sense of controlled urgency. Your conclusions are not going to be stated in terms of likelihood, but rather as an absolute. And you're going to always want to state it in the light that's most favorable to your client. And while it's definitely good, you should always acknowledge the other side's arguments, you're going to downplay them and attack and undermine them as much as possible. And again, to do all this, you really probably need to employ the CRAC formula. I can't really think of an example where you would ever want to employ the IRAC formula in this particular setting if you were doing a brief or a motion or a letter to opposing counsel. Okay, so we've pretty thoroughly covered legal analysis. Now let's turn our focus to legal writing. And again, as I mentioned at the beginning of this presentation, legal writing these days really just means writing as plainly and precisely and unambiguously as possible. Because the goal when you're writing any sort of legal document is to communicate the information that you've learned in a way that makes it easy to understand and very unlikely to be misinterpreted. And the way you can do that is really just by employing really good sound grammar, which I know sounds strange, but as we go through this, I think you'll start to see what I mean. So first, let's talk about how do you build a good, strong sentence. Well, maybe thinking back to your early days in an English class in elementary school, for example, we know that the three basic elements of a declaratory sentence are a subject, which is the actor, a verb, which is the action, and then the object, which is the thing that receives the action of the verb. So with those three elements in mind, A good, strong sentence will put the subject, verb, and object in that order, close together and as close to the front of the sentence as possible. So for example, the class ate the snacks. Here you have the subject, the class, the verb, to eat, and the object, the snacks, in that order. And it's, I mean, they make up the entire sentence. There's no other information provided. So just that's a good example of a strong, simple sentence. So compare that to the following slide. The dog, whose name is Greta, who weighs well over 75 pounds and who is half German Shepherd, a quarter Husky, and a quarter wolf, chased the cat. So here we have a very long separation between the dog, which is the subject of the sentence, and the verb, which is chase. So what happens when we employ something like this as a writer is it forces our readers to kind of mentally hold their breath while they wait to find out what the subject of the sentence did. So that energy is really not energy you want them to spend just waiting to find out what the action is going to be. You want them only thinking about your legal points and your and how persuasive they are. So the best way to do that is to kind of eliminate these kind of mental hurdles that your readers have to overcome in order to kind of get to the point of what you're trying to say. So in a situation like this, you would really want to pair the subject and the verb together as early as possible in the sentence, rather than separate them as two separate entities by a bunch of other words that really aren't significant to the information you're trying to convey here. Okay, so in addition to sticking with the sort of three basic elements of a good sentence and keeping them in the subject, verb, object order and putting them together as close together as possible, another thing that's helpful in legal writing is to try to focus on using the active voice whenever possible. There are admittedly some situations where the passive voice is more appropriate, and I'll talk about those in a minute. But essentially what the active voice means is that the subject of the sentence is performing the action, as opposed to the passive voice where the subject is receiving the action. So really simple illustration, the dog chased the cat is an example of active voice, whereas the cat was chased by the dog is an example of the passive voice. So when might the passive voice be appropriate? Well, sometimes you don't know who the actor was. So, let's say you're in a situation where you know that a package was wrapped in brown paper, but you don't know who did it. You could just say something like, the package was wrapped in brown paper. It's an accurate statement based on the facts that you know, but you can't really speculate as to who did it. So they're using the passive voice to convey the information you know, but not go beyond, things that you don't know. For example, who did it? That would be an appropriate situation to use the passive voice. Another reason you would want to use the passive voice might be if you're trying to de-emphasize the person who did it or who's alleged to have done it. So say you're a criminal defense attorney and you're representing someone who's charged with murder. You don't want to say, my client killed the victim, because you're trying to disprove that exact fact. So instead you might say something like, the victim was killed. So there are definitely situations where the passive voice is appropriate, so you have to be thoughtful about it. But generally speaking, the active voice is preferable for a few reasons, especially in legal writing. So let's look at the examples on the slide. The example of good active voice is the court used a 3-part test to determine whether the evidence was admissible. Now, the bad passive version of that sentence would be, the admissibility of the evidence was determined by a 3-pronged test. So there's a few things I want to highlight here on this slide. The first is, if you look at the subject of the good active voice example, you see that it's a very short and, more importantly, concrete noun, the court. And when I say concrete, I mean a court is something that you can see, you can hear, you can smell, you can perceive it with your senses. If you think to yourself a court, you can immediately picture what's being discussed. But if you look at the bad passive voice example, you see that the subject is the admissibility of the evidence. which is this much more, first of all, it's very long and wordy, but it's also, more importantly, it's very abstract. You can't picture what admissibility of evidence looks like, smells like, sounds like. You can't really perceive it with your senses. And so this is another one of those things where if you phrase something in the passive voice, you're sort of forcing your reader to expend mental energy to picture what you're talking about, when they really should instead be focusing on the point that you're trying to make. So so again, using the active voice, one of the reasons to do it is because it allows you to focus on nouns that are short and concrete, as opposed to really abstract and fuzzy and difficult to conceptualize. Okay, so another helpful tip when it comes to writing as clearly and concisely as possible is avoiding what's known as nominalizations. So a nominalization is basically just a word that should be a verb, but instead has been turned into a noun. So for example, John's decision was made too hastily. In this example, the word decision is a nominalized form of the verb to decide. So a really simple way to reword this to avoid the nominalization would be to say something like, John decided too hastily. So the reason you want to avoid nominalizations is because, much like using the passive voice, using a nominalization often weakens and softens your sentence, because the subject becomes something abstract rather than concrete. So, and the other thing it does, unfortunately, is it turns the because the verb is now the noun, the verb that you end up using, in this case was made, loses all of its power. So really, nominalizations are basically just sort of another version of passive voice in that sense. So because again, you want to use, strong, concrete, simple nouns as your subject, and you want your verbs to have some punch to them. So let's see, let's look at an example. And again, if we were in sort of a less formal setting where I could just call on folks, I would ask someone to call out what the nominalized verb in the following sentence is. Since I can't do that, I'm just going to go ahead and get right to the point. So pretty clearly, the nominalized word in this sentence is rejection, which is just a noun form of the verb to reject. So, let's say you're the writer and you're trying to edit now for, and by the way, most of these, writing in plain English tips are not things that normal people think about as they're writing. It's really more editing where this comes in, and writing and editing are two very separate stages. So, if you find yourself, writing something out for the first time in a first draft and you're using the passive voice and you're using nominalizations, don't beat yourself up. I do that too. But the point is, hopefully you have enough time at the end when you're done to go back and edit, and then you can look out for these little things that you can correct by, maybe changing to the active voice or rewording to avoid a nominalization. So just to be clear, no one expects people to be able to do this right off the bat. It's quite difficult. But so let's say you're in editing mode and you get this and you come across this sentence that either you or maybe someone else has written. How could you reword this to avoid the nominalization? So again, I can't unfortunately call on anyone, but on the next slide, I do have a sample revision. And of course, there's different ways you could do this, but here's how I would reword it. I would say something like, an insurance claims agent should not reject an insurance policy holder's facially valid claim without good reason. So notice how, again, we went from a subject that was very abstract and fuzzy, which is rejection of an insurance policy's facially valid claim, to suddenly now we have a very concrete noun as the subject, which is an insurance claims agent. That's a person, you can picture them. Maybe you're thinking Jake from State Farm. That's certainly what I think of when I hear this sentence these days. So again, just avoiding nominalization is one extra little tool in your toolkit when you're editing, to help make your writing a little bit more clear and concise. Okay. Another thing that we tend to do as writers that kind of leads to abstractions is starting sentences with it is and there are. So a really simple way to catch this is, if you ever see a sentence that starts with it is or there are, just pause and ask yourself, what is the it, or where is the there? And if the answer isn't obvious, chances are you can edit the sentence by focusing on the actor and the action that you're trying to describe, rather than some fuzzy indefinite pronoun. So for example, instead of saying something like, there are 3 reasons why this court should reverse, you can very easily reword that sentence to, this court should reverse for 3 reasons. And again, notice that now we have this really strong, simple, concrete noun as our subject, making it much easier for our reader to visualize and quickly jump on board with what it is we're trying to say. Another example is, so that was an example of there are. An example of it is would be, it is likely that Mr. Mao will be chased by Austin. Just to clarify, Mr. Mao is our rescue one-eyed cat, and Austin is our rescue dog, and they have a very typical cat-dog relationship. You could change this sentence to instead say something like, Austin is likely to chase Mr. Mao. Now suddenly we have a very concrete subject for the action, which is to chase, and Mr. Mao is the object receiving that action. But just to be clear, there are situations where it is or there are totally appropriate. So for example, if you said something like, the motion arrived this morning, it is on your desk, in that situation, the it is plainly referring to the motion. So the pronoun makes sense in that context, and it's not some abstract, difficult to conceptualize thing. It's this concrete thing. It's the motion. So again, it's not, these aren't like hard and fast rules that you should just apply blindly. Like unfortunately, you do have to kind of sit and think, what am I trying to convey here? But if it does turn out that you're using it is or there are as these fuzzy indefinite pronouns, like there are simple ways to reword those sentences. So you just want to be on the lookout for that as you're editing. All right. And then let's see, I think I'm down to my last 3 tips. So we're getting there, folks. Thanks for sticking with me. So another helpful thing to do when trying to write in plain English is to avoid compound constructions. And really all that means is avoiding situations where you're using 3 or more words to do the work of just 1 or 2. So for example, if someone wrote, the parties were in complete agreement with respect to the amount of rent due and also as regards the due date. That sentence is technically correct. There's nothing wrong with it, but it's kind of complicated and hard to follow because it's wordy, right? So a way to simplify it would be to avoid the compound constructions and instead change it to something like, the parties agreed completely about the amount and due date of the rent. See how that sentence, it's a little shorter and snappier, and more importantly, from a reader's perspective, it's a lot easier to understand. So again, as you're editing, just look for opportunities to kind of trim down words and be a little bit more concise in your overall writing, just to help out your reader and make things a little bit easier to understand. On that note, using shorter sentences in general is a pretty good practice that lawyers should kind of be on the lookout for. And the really simple way to do this is to, if you find a really long sentence in your own writing as you're editing, if you see that it's merging a bunch of independent thoughts, just take each of those thoughts and put them in separate sentences. And I know sometimes that feels a little choppy, but again, that it's more about trying to help out your reader so that they can understand what you're saying more easily. So here, I'll put an example on the next slide. So here's the wordy long version, long sentence version of this statement. By establishing a technique whereby the claims of many individuals can be resolved at the same time, class actions serve an important function in our judicial system in eliminating the possibility of repetitious litigation and providing claimants with a method of obtaining enforcement of claims that would otherwise be too small to warrant individual litigation. So again, there's not anything technically wrong, but that was a really long sentence that conveyed a lot of different ideas. And kind of by the end of it, I personally forgot what we were talking about. So a helpful thing for your reader so that they don't lose track of what you're trying to say would be to break that down into at least 2 sentences. For example, class actions serve an important function in our judicial system because they permit courts to resolve claims of many individuals at the same time, period. New thought. This avoids repetitious litigation and allows litigants to enforce claims that are too small for individual litigation. So there, it's a little bit easier to digest the information because you're getting it in smaller chunks. So again, always be thinking about your reader. And if you catch yourself writing a really long sentence, just ask, how many ideas am I trying to convey here? Because if it's more than one, I should probably try to split this into 2 sentences. And then lastly, and this is a funny one, but we as lawyers, there's a lot of jargon that comes with our practice. No matter what type of law you practice, there's going to be kind of a lot of little shortcuts that we use and things like that. But more importantly, there's a lot of like Latin in our field, in our chosen field, and a lot of just kind of very lawyerly sounding words that I think some people employ because they feel like it elevates the writing, but oftentimes it really just confuses the reader. So we call those lawyerisms, and I recommend trying to avoid them as much as possible because they don't really accomplish anything other than potentially obscuring meaning. So for example, you could, if you find yourself writing something like, the prisoner's aptitude for acclimatization to lack of confinement is one factor that must be taken into account in the deliberations of the parole board. So first of all, that's written in the passive voice. So that would be one thing we'd want to fix. But in addition, it's also just really jargony. And a lot of those words, it kind of just sounds like someone grabbed a thesaurus and tried to use the most complicated sounding words that they could find for what they were trying to say. But really, again, from your reader's perspective, they have to pause each time they hit one of those kind of lawyerly sounding words and ask themselves, like, okay, what does that mean? Okay, now I'm with them. But each time they exert that mental energy, they're not focusing on the point you're trying to make. So we want to avoid that. And one way you could do that is by just taking out all those lawyerly sounding words in the first place and just simplifying the sentence and also changing it so that it's active voice. So that now it says something like, in deliberating, the parole board should consider the prisoner's ability to adjust to freedom upon release. See how those 2 sentences literally say the exact same thing, but the second one is so much easier to understand more quickly. So from your reader's perspective, you've taken out all the mental energy that they need to exert kind of analyzing your word choice, and instead they can just understand the point you're trying to make, which is the goal of legal writing at the end of the day. So we have about 7 minutes left. I did not see questions popping up, but if I missed any, please, Carlos, let me know. I see you just popped on. So yeah, did I miss any questions? Are there new questions that I should be addressing?
There's one right there on screen.
Oh, great. Okay. Let's see. Let's see. So, and sorry, Carlos, I don't need to restate it because everyone can see the question as well, correct?
Yeah. Mm-hmm.
Okay, great. Mm-hmm. So I don't know if I would say that it's more common. It might be if you're, again, like I mentioned, if you're talking about when you say defending side, if you mean criminal defense, oftentimes there's a need for the passive voice because your position is that your client is not the person who committed the alleged crime. But that doesn't necessarily mean who did. So in that situation, when you don't know who the actor is, like I mentioned, you would want to use the passive voice. But that being said, like that's sometimes criminal law, it doesn't come down to that issue of the defendant's identity. Sometimes there's no question that the defendant did something. The only question is whether that action should, what crime should that be considered? So I think it's definitely just as likely to use the active voice on the defense side if we're talking about criminal cases. Yeah, honestly, but the passive voice is so prevalent just in general because I don't think people really look out for it when they're editing. So again, I would just kind of urge everyone here, and include this is, I have to do this myself too, just look out for it in your own writing because it is easier to understand an active voice sentence than a passive voice sentence. So yeah, so no matter what area of practice you're in, usually active voice is going to be your best friend.
Thank you for that. Thank you for the question, Celestia. Any other questions? We have 5 minutes left, and this is sort of question time. I know folks were asking for the slides, Tiffany. Is that something that we can provide?
Absolutely.
Okay.
If I send them to you, is there a way somewhere you could post them where they would be accessible?
Yep. Yeah.
Great. Yes, I'm happy
Okay.
to send those after this is over.
And so for the folks who registered through Eventbrite, you'll get like a post webinar email, and I'll include the slides in that. And also, this recording is going to be on YouTube. So if you ever want to come back and go back to a certain section of Tiffany's presentation, you can rewatch it. Any other questions? We have 4 minutes left. Lots of praise for you in the comments.
I hope this was helpful. Again, I think legal writing doesn't get highlighted as much in law school, but it's such a big part of what we do as lawyers, no matter where we are in the country, no matter what our specific area of practice is. By the way, I don't think I mentioned this. I specialize in appellate law, so I really spend most of my time writing, which is why I'm kind of a little obsessive about this stuff. But it really does, it makes up such a huge part of my practice. And even if you aren't appellate practitioners, I'm sure you all do spend a lot of time writing. So I hope it was helpful, and I really appreciate you all attending.
Thank you so much, Tiffany. I know that, like I said, it is one of the most requested topics. And so we really wanted to honor what our fellows and scholars were telling us. And we will have more opportunities for you all to interact with Tiffany next week. I saw that a lot of people throughout the hour were signing up for next week's session too. That's going to be on oral advocacy. But also, I just dropped into the comments a link to a feedback survey. So if you can, it's like 4 or 5 questions, really simple questions. But we're looking for feedback from you all about what you liked, what you want more of. Do you have any other ideas for either legal skill type webinars? We would love to continue working, obviously, with Tiffany in the future, or any other topics that you think you need to succeed as lawyers and as legal professionals.
I'm sorry,
Tiffany,
Carlos, I don't mean to interrupt, but I did see one other question. And I just wanted to briefly acknowledge it. It was, do you have any suggested workbooks, et cetera, to improve / develop our writing? I do have 2 or 3 textbook or, just sort of helpful writing tip books that I've used as references in my practice. I don't have the names off the top of my head, but I will go find them on my bookshelf, and I will include that in my email to Carlos when I send the slides. So I will take care of that for you. But yeah, great question.
All right. Thank you, everyone. Thank you so much, Tiffany. We'll see you 1 week from today.
Great. Sounds good. Thank you all so much for being here. See you soon.
Bye. All right, everyone. Thank you so much. Remember to fill out the feedback survey that is in the comments. Tell us what you thought of today's presentation, and let us know if you have ideas for future content. And with that, we're going to sign off, and we'll see you next week. Bye, everyone.